Welcome once again to Lehto's Law. Here's Steve Lehto.
I've never owned lakefront property, but I've known people who have, and I've stayed with somebody on a piece of lakefront property. And it's great. You look out the window, there's the beach, there's the water, there's sailboats off in the distance. Ain't nothing more comforting than that. And then people go walking by on your beach. And the question is, can they do that? Because that is a source of a lot of friction in lakefront communities. And I can tell you that property I'm talking about right now, the owner of that property didn't mind people walking back and forth across the beach in front of that piece of property because they understood that you have to let people do that, at least in Michigan. And so next door, however, was a guy who'd lived there for years, who didn't like people walking across his beach. And every year he'd put no trespassing signs on the beach facing away from his property. So people would come walking along the property and they'd encounter a no trespassing sign. Now, most people would just step over it and keep walking. And occasionally the guy would come out and yell at him, "Can't you read?" And people would occasionally yell back, "Yes," and keep walking because he had no right to do that. But here's the situation. This is out of Indiana. Federal appeals court affirms public ownership of Lake Michigan shoreline. So Lake Michigan is surrounded by a whole bunch of states, including Michigan. Dan Carden wrote the story for the NWI Times .com. Trocon sent it to me. A federal appeals court has declined to disturb an Indiana Supreme Court ruling, which was later codified into state law, declaring the shoreline of Lake Michigan is and always has been owned by the state for the enjoyment of all residents. In a unanimous decision, the 7th U.S. Circuit Court of Appeals in Chicago said Wednesday that the 3 property owners who had lake-adjacent property in the town of Porter, who claim their holdings include a private beach on Lake Michigan, lack standing to challenge the Indiana High Court ruling and statute in federal court. This case is convoluted, but these people are putting up a fight. Circuit Judge Diane Wood, writing for the Federal Appeals Court, said that the homeowners failed to establish their beach property was taken by the state because there was a ruling back in 2018. And I think I did a video about that back in the time, but I'll have to go take a look. And in that case, the Indiana Supreme Court clarified that these people never owned the private beach on Lake Michigan. So a lot of people, when they look at the piece of paper that describes the shape of their property, will look at it and see that the property line goes out onto the beach. But the reason it does that is that you actually own the property up to the high water mark, the traditional high water mark. They have different phrases for it, and I'll get to that in a second. And because that theoretically could change over the eons, they just draw your property line down to the water. But you don't own it just because a piece of paper says that, because state law will trump what that piece of paper says. The decision there held that Indiana owns the land under Lake Michigan and the adjacent shoreline up to the ordinary high water mark, and that's been the case since Indiana became a state in 1816. So Indiana has owned that land since 1816. So unless you bought your beachfront from the state, you're over. You're done. The ordinary high water mark is defined as the line on the shore, established by the fluctuations of water and indicated by physical characteristics such as a clear and natural line on the bank, shelving, or changes in the soil's character. And the lakes do fluctuate quite a bit. It depends on where you are and how steep or shallow the bottom is going underneath the water. I know places in Lake Michigan, up near the Old Mission Lighthouse, where if the water drops a couple inches, it can run the shore out quite a ways because it's such a gradual decline in the bottom there. The Gunderson ruling is what they call it, was codified in 2020 as an actual law in Indiana, along with the right of all people in Indiana to use the shoreline for walking, fishing, boating, swimming, and other recreational purposes for which such land is often used. The law enacted by the General Assembly also specified Lake Michigan adjacent private property owners are not entitled to exclusive use of the beach or the water. So you own the property up to an extent, the state owns the rest. And the bit that the state owns, people can hang out on that. There's not much you can do about it. The judge said that even if the plaintiffs here owned the entire shoreline near their homes, the individuals they sued have no authority to convey title to land that the Indiana Supreme Court and the General Assembly say belongs to the state. What they're getting at here is, I'm sure you've often heard, when somebody has a problem and they have to sue the state, they'll often name different people at the state. The governor, or the Secretary of State, or a sheriff. And a lot of times they're doing that because they're basically saying, look, this department run by this person's got the authority to do something. We want them to do it. And in this lawsuit, apparently, the plaintiffs sued the governor, the attorney general, the directors of the DNR, and the state land office. And the federal court saying, even if your argument was correct, you've sued all the wrong people. These people can't convey land title to you. Moreover, she said a federal appeals court lacks the authority to overrule a state Supreme Court. In this situation, what the federal appeals court is pointing to is that there are some things that are left to the states. And we could talk all day long about the 10th Amendment. We're not going to do that right now. But there are certain things that the states are left to handle. And one of the things that is extremely dependent on state law is property ownership. How you own property, what you can do with your property, things like that. And the court here is saying this is an issue that the state Supreme Court gets the final say on because it involves property in Indiana. It is the state property law itself, rather than any action by state parties, that is adverse to the owner's claims. We would be unable to hold that their property was taken without also holding that the Supreme Court of Indiana was wrong in the Gunderson case. In effect, their theory of the case would have us sit in appellate review of the Indiana Supreme Court's decision about state property law, a role that would sit uneasily next to the Supreme Court's exclusive statutory authority to review the decisions of state courts in civil cases. Records show the Long Beach Lakefront Homeowners Association appealed the Gunderson ruling directly to the U.S. Supreme Court back in 2018. So, case made at the Indiana Supreme Court. The legislature passed a law codifying that ruling, and the same people who lost at the Indiana Supreme Court filed an appeal with the U.S. Supreme Court, and that was turned down. So then they filed a claim in federal court. The nation's high court turned away the case without comment in February of 2019, seemingly content to leave the Indiana Supreme Court ruling as the final word on Lake Michigan beach ownership in Indiana. An attorney with the Pacific Legal Foundation, which is a California-based property rights law firm representing the plaintiffs, did not say whether they plan to ask the U.S. Supreme Court to review this decision. He said, "We are disappointed in the outcome, and we are considering our next steps with our clients." Indiana Attorney General Todd Rokita did not immediately respond to a request for a comment on the ruling. Last year, when the U.S. District Court Chief Judge initially rejected the beach ownership claims, Rokita said the court's decision affirms what we always knew to be true, that the shoreline of Lake Michigan belongs to every Hoosier for their use and enjoyment. One thing I will point out, that your right to be on the beach does not necessarily grant you the absolute right to get to the beach. So for instance, if you had 10 homes, 10 pieces of property that are adjacent to one another, and there was no path to the beach through there legally, there was no public sidewalks or anything like that, no easements had been granted, and you've got these homeowners along here, and you've got the beach down here, and people are allowed to walk to and fro on the beach, does not mean they can cut across this property to get there. Now, if they can get to either end of that, yeah, they can walk back and forth all they want. So the example that I gave of my friend my friends who owned the cottage, and they had beach in front of them, and their neighbor who put up no trespassing signs. The problem there is there was a campground about 200 yards that way, and there was a public beach about 100 feet that way. So people would routinely walk from the campground to the public beach, or from the public beach to the campground. And the funniest thing of all was that everyone in the area knew who the various homeowners were along here. Everyone knew, oh, by the way, there's one guy who puts up no trespassing signs. Just ignore him. And they would tell people that. And I remember sitting out on the beach, someone go walking by, hey, how you doing? Good, how are you? And they walk along, and all of a sudden I hear, hey, can't you read? Someone goes, yeah, have a nice day. Just keeps walking. So, I agree that there are people out there who will abuse something like this and, build a gigantic bonfire on the beach right there and then leave the mess when they're done, or not even put it out. Just walk away from a bunch of smoldering embers on the beach. And so there are problems, but you should know that going in. And, a lot of people will buy a piece of property and then complain about what happens when they should have known that going in. We've talked about this before. Someone buys a piece of property next to a farm, and then all of a sudden, one warm day, they go, hey, those people are raising pigs. Ask me how I know. And they complain. Hey, these people, they're farming on their farm. I don't like them doing that. Or people who buy a home near the drag strip. There's still a few of those out there. Did you know on Saturdays and Sundays, they make a lot of noise? Can you make them stop? And so you should actually think about these things when you're buying a piece of property. And if you buy a piece of beachfront property, understand that that might come with people on nice days walking across your beach. And in Indiana, it's now been upheld again that people have the right to walk on the beach up to the ordinary high water mark. And right now, the lakes are low. The lakes are low. But a few years ago, they were high. And so literally that changes every few years as to how much beach is going to be there. But they are always allowed to walk up to the ordinary high water mark. You might say, Steve, what happens if the water actually makes it all the way up the high water mark? Can they walk on the beach? Well, theoretically, they can walk in the shallow water right there because that's below the ordinary high water mark. So there you go. Trocon, thanks for sending it. Federal Appeals Court affirms public ownership of Lake Michigan shoreline. I have a sneaky feeling this one's not over yet, but we'll see. Dan Carden wrote it for the NWITimes.com. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Is it better to have something that you don't need than to need something you don't have?